Sarah, the website is still nigerianbar.org, right? I think I'm not
Sarah.Ajijola.
Yes, at nigerianbar.org. Okay, good. I've sent it. You should come in by the bar.
So Sarah, please let me know when you get it so that we can start, please. Sarah, do you have it yet? Because of our time. Okay. Good afternoon, my lords, distinguished senior advocates of Nigeria, distinguished senior colleagues, and my fantastic colleagues on the call this afternoon. On behalf of the MBA IC I welcome you to this training webinar on data protection and privacy. Before I delve into, or before I introduce the first facilitator, we're waiting on something on the back end for me to bring him upstage. So this training is going to span 4 days, and today we're having 3 distinguished senior advocates of Nigeria who will be taking us through the rudiments first on privacy and data protection with respect to the courses of action, and also some parts of the Nigeria Data Protection Act 2023. So without wasting our time, I'd like to introduce to you Professor Deji Adekunle SAN. He used to be the Director General of the Nigeria Institute of Advanced Legal Studies, and now he's he's one of the few academics actually who have written on privacy and data protection. His major article on the subject was published by Oxford, and that's the International Data Privacy Law. That's like the biggest journal that publishes academic papers on privacy and data protection around the world. So without wasting much of our time at all, because we have 3 speakers today, please join me as I welcome, so that he can take his session, Professor Adekunle SAN. Thank you. Over to you, Prof.
Thank you very much, Mide. I hope I'm audible.
Yes, you are. Yes, yes.
So if that's the case, while we wait for the slides to be shared, Let me say first how appreciative I am to be on this program and to pay compliments to the team of the Continuing Legal Education Committee of the MBA, and to say how very well thought out this training is. To have lawyers look at the Nigerian Data Protection Act 2023 and to see how it impacts practice as well as institutional activities. This is one legislation that cuts through the activities of everyone, whether you are an individual or whether you're a corporate person, whether you're in the public or private sector. And my presentation this afternoon will look at the overview. We're doing an overview of the Act, and I see that I have 40 minutes or so to do that. In order to allow for interaction, I'll probably be taking less than 40 minutes. My presentation will start with an intro. We'll look at the scope. We'll look at underlying principles of the Act. We'll look at the rights and responsibilities under the Act. We'll talk about compliance issues, enforcement. We'll then go on to remedies and the next steps, which will be like my conclusion. Before 2023, those who are familiar with this talk will know that there was the NDPR, the Data Privacy Protection Regulations of 2019. And it was because of the uncertainty about the enforcement of that instrument, probably, that led to the blossoming and strengthening of regulatory framework in relation to data protection and privacy. The primary object of this act, that is the NDPA, is to provide an efficient regulatory framework for the protection of personal data, regulate the processing of information relating to data subjects, and safeguard the fundamental rights and freedoms of users of data. Other objectives include the promotion of a code of practice, and to minimize also the harmful effects of personal data misuse or abuse on data subjects. Now, if you recall what has been happening, particularly in the field of mobile lenders, mobile telephone lenders, and probably some of you may have received all kinds of messages on your phones about how someone had dropped your name or your details as guarantors. And some of you who haven't been that fortunate or unfortunate would also recall the steps taken by the consumer authorities, the consumer protection authorities. You would understand why data protection is very useful and needful. It is important that we use data in an environment of trust and in an environment of security. Because that's the only way that the digital economy can blossom. If operators, if manufacturers, if service providers do not feel secure in the provision of services, if consumers do not feel secure in using those services, there's no way that the digital economy will blossom. And so for governments and data protection authorities, the primary concern is to ensure sustainable and responsible use of data in a data-driven economy. So you will find, therefore, that all through the NDPA, that's my short form for it, I call it NDPA, you will find it's laced with responsibilities trusted upon data operators, data controllers, responsibilities trusted on the protection agency, on the ministry, as well as on users. I like to talk a little bit about best practices. So data protection is not new. It's not new to us in Nigeria. It's certainly not new. I'm about 4 slides away now. Yeah, yes, thank you. Conventional law and best practices. That's the slide I am on. Conventional law and best practices. Yes, thank you. So in 2014, the African Union elaborated a Cybersecurity and Personal Data Protection Convention. It's called the Malabo Convention. It did not come into force until 2023. Unfortunately, Nigeria has neither signed or ratified the Malabo Convention, although we did sign and ratify the Budapest Convention on Cybercrime in 2022. So when you compare us to a country like Ghana, Ghana is one out of 12 nations in Africa that not only possesses a national cybersecurity strategy, but also has an incident response capacity. It is only one of 4 countries to have ratified both the Budapest and the Malabo Conventions. These 2 major treaties aim at addressing digital security and use. I believe that the first thing that any observer notices with the NDPA is that, laudable as the objectives of the acts are, it's going to have serious challenges when it comes to working with neighboring or regional partners. But I dare say that looking at the ECOWAS sub-region, I believe that Nigeria is signatory to arrangements within the ECOWAS region, because cybersecurity clearly knows no borders. So let's look at the scope and application of the NDPA. First, the Act applies to the collection, storage, processing, and use of personal data. The key word there is personal data of persons residing in Nigeria and persons of Nigerian nationality by automated and non-automated means, irrespective of residence. The Act applies to personal data processed by entities in the private and public sectors based in Nigeria. The Act also applies to a data controller and a data processor in respect of personal data where the data controller and data processor are both established in Nigeria. And the personal data of data subjects in Nigeria are processed within Nigeria. Where the data subject resides within or outside Nigeria. Now, there is a problem there for me because I think that in terms of the scope and application of the Act, it cannot have that extraterritorial reach to the extent of affecting persons, to the effect of affecting persons where the data controller or the data processor does not reside in Nigeria. You know, so for example, if a data processor or controller resides perchance in Ghana, and we're talking about a Ghanaian resident outside Nigeria, there is no way that this Act can apply to such a person. However, if the Ghanaian resides in Nigeria, yes, there is some territorial basis for application. Most regulatory laws usually have this territorial application. So I don't see any reason why this is different. It's only countries like the US that try to have extraterritoriality in their laws. So much for geographical scope. What of persons? Personal jurisdiction. The data subject must be a citizen of Nigeria or must be ordinarily resident in Nigeria or must be a body incorporated under the laws of Nigeria or an unincorporated joint venture or association operating in whole, in part, in Nigeria. Any person who does not fall within the above 4 paragraphs but maintains an office, branch, or agency through which business activities are carried out in Nigeria also come under the Act. And foreign entities targeting persons residents in Nigeria. So this further confirms. That's next slide, please. Thank you. Next slide. I'm on to scope in relation to persons now. This further confirms, no doubt, that paragraph that talked about persons that are not residents in Nigeria must obviously have been a drafting error. Note, this Act does not apply. This Act does not apply to processing of personal data carried out by a data subject in the course of a purely personal or household activity. So if your child or your ward is in the business of his assignments or arranging household expenditure, this Act does not apply to that activity. What does the Act mean by personal data? It gives an example. Anywhere you see in an Act where the word include is used. It's simply an example. So it does not intend to be exhaustive. I'm in subject matter now, scope, subject matter. That's the next slide. Thank you. So the Act applies to the following kinds of data: personal and biometric data, personal banking and accounting records, personal data revealing itinerary, flight reservation or itinerary, and that will include hotel reservation, students' academic transcript records, personal medical and health records, and so on and so forth. Now, every country actually can, please go on to the next slide, can actually determine what it wants in terms of data protection. But like I told you, if you look at Africa generally, the AU already has a convention. Europe has a convention. We're not signatory to the AU convention, but I believe that there are quite a number of principles in the AU convention that are replicated in the Nigerian Act. So what's the first principle? Data must be obtained and processed lawfully and fairly, and as much as possible transparently. As the first best practice, it's an international principle that's adopted by the AU and by the European Union GDPR. Under the NDPA, it is stated that data should be processed in a lawful, fair, and transparent manner. It did not include the word obtain. I dare say before you process, you should obtain anyway. But sometimes these things bear emphasis. And I can't help feel that it's because we were not signatory or we did not really study the African Convention and the guidelines advanced under it, that we're having to experience some of these glitches. 2, purpose specification. Personal data must be collected only for specified, explicit, and legitimate purpose. And once collected for that purpose, it should only be used for such other purposes that are compatible with the explicit purposes as well as applicable laws. Under the NDPA, this duty or this principle is also expressed in terms of specific, explicit, and legitimate purposes. And that any other purpose that is adequate, relevant, and limited to what is necessary in relation to the purpose for which the data is processed. Number three principle is that of use limitation. Personal data must not be disclosed or made available or used for other purposes except with the consent of the individual or where authorized by law. Although this is not explicitly stated in the NDPA, you will find that it is implied under 2 above, and also under paragraphs C and D. That is, personal data must be processed for purposes compatible with those for which the data was initially collected. Quality. The NDPA states this clearly, that data must be accurate and regularly kept up to date. We'll come back later to that reference to period of retention. We don't have a period of retention under our laws. Again, an unfortunate consequence of not keeping to regional standards. or international best practices. 5, security safeguards. Personal data should be protected by reasonable security safeguards in order to maintain its integrity and confidentiality. This is incorporated in the NDPA. 6, individuals must have a right of access to information about them. Again, the NDPA provides for this expressly in section 6. And then the last principle, which is best practice. So internationally, there are actually 8. We have 6 expressly provided for under the NDPA. When you drill down on those 6, probably you can extend one of them to cover issues, to cover 1 or 2 other principles, but 2 very important principles, that of retention period and accountability, seem to be missing in our framework. Next slide. So the Act, like I told you, the Act looked at sustainable use and sustainable and secure use. And in doing that, it provides for certain rights for users or data subjects. Let me put it that way. I think it's better to use the data subjects, because in the data protection framework, you have the data subjects, who is the owner, the person to whom personal data refers to, the person who the personal data refers to. Then you have the data controller, who is the owner of the forum, the establishment, or the media or medium through which data is being processed. And then you have the data processor, who is the person usually under the employment of the data controller or under some contractual obligation of the data controller, who processes the personal data. So that's like an employee of the data controller. So for example, in this, to just put it plainly, MTN, I think it's limited. MTN Nigeria Limited is a data controller. The processors, those who operate their data banks, those who process and store logs, call logs, these are the data processors. And you who subscribe to MTN, you are a data subject. And then you have above these 3, you also have the Data Protection Agency or Commission. And above the commission, you have government, which is like a ministry. That's in this case, the Ministry for Information Technology, MICT. So that's the structure, really. And the structure is geared towards providing rights for data subjects, and the critical rights in any data protection regime is informed consent. Informed consent. While consent is the basis for a number of provisions in the Act, unfortunately, I have found that some aspects of this right has been rendered illusory by the NDPA, in the sense that compared to other regimes where privacy is protected by default. There is a default privacy regime in place, whereas what the NDPA has foisted on us is you have to consciously assert this right. You have to consciously demand of the data processor or the data controller that these rights should be enforced. There is a tension there because most of our people really, they are not aware of some of these things. You just want to do your business and get on with it. So if you do not request, I just saw a question pop up there, how do we demand? Exactly. Most of the time, you don't even know who you are going to demand these things for. So that is why in other countries, the default is to operate in a way that you do not disclose. You did not disclose personal data. So let me give you this basic example. You go on a website, you have the first time visit to a website. Immediately something pops up. We use cookies in this on this website. You can either accept or you can tweak your choices in such a way that we can increase our level of sharing information. But if you don't choose anything, the default operates, and default simply means that only essential information about you is collected and shared. So that is what is called the principle of privacy by design and by default. Now, it really does not, practically, it does not matter much in the country, because you'll find out that even in this country, this kind of cookie policy, I will put it there, or privacy policy, operates fairly on every website. There are some websites, however, who don't give you that option, and such websites, I'm afraid, are in breach. They are in breach of the data protection principles. You need to give them an option. But what it does mean, some websites will close if you don't accept. Some will go on, and that simply means that they have activated the privacy by default for you. So that's the way it works. So privacy, next slide. Privacy is a constitutional construct under Section 37 of our Constitution. Privacy entails the physical and psychological space within an individual's control. The physical and psychological space within an individual's control. That is why when you are shouting in an enclosed space, people say that you are invading the privacy of others. When you play music in an enclosed space, it's a problem. So it doesn't really, most people think privacy has something to do with hiding something. That's not really what it means. Privacy is really quite broad. And of course, it extends to your vital documents. It extends to your vital documents and also personal data. And I recall that in the wake of the Freedom of Information Act, when the issue had been that, oh, we really need to also talk about data protection. And the talk then was, if you do that, you can say curtains to freedom of information. But as you can see, even under the Constitution, there are circumstances where privacy rights will not apply. Although such circumstances have to be reasonable and justifiable according to Section 45 of the Constitution. And there are a number of exceptions, even under the NDPA. The next slide will show you that. The next slide will show you the exceptions. These are well-known exceptions: public order, public safety, morality, national security, public interest, and so on and so forth. I don't want to waste too much time on that. The second right, next slide, is right to transparency. And the right to transparency means that a data controller shall inform the data subject of the official identity, residence or place of establishment, contact details, and the legal basis and purpose of the intended processing, including the categories of personal data processed. So what I'll just invite you to do, just go on Facebook. If you have a Facebook account, if you have a Twitter account, if you have a WhatsApp account, go to settings and you will see somewhere where it says contact us or about us, and you will see all this information there. Facebook is even more elaborate. It contains a lot of information about why it collects data and what it uses those your data for, and how you can minimize. Yes.
I'm sorry, because of our time, there are a couple of questions in the chat room. Maybe you can quickly speak to your mini slides so that we can take the questions because of our time.
Okay. Okay. Thank you very much. I'm actually trying to rush now. So that's transparency, to tell people what your policies are and how you deal with them. The data subject has a right to be notified of a data breach, and you have a right of access to your data. You have a right of access to your data, a right that you can, and I think some of these things will probably be taken care of in the subsequent presentations. You also have a right to rectify or delete inaccurate data. Again, there is some omission here. Under the EU and under the African Union law convention, you have a right to rectify data that is no longer necessary to keep. But under our law, it's basically on the basis of inaccuracy, or where the reason for holding on to the data or creating the data no longer applies. I've told you about who the data controller is. He also has some duties. The data processor is also obliged to do a lot of things. Basically, and I'm on objectives of regulation now. Basically, the Data Protection Commission sees to compliance about the act. And I'm not going to reel out the mandates and functions of the commission. If you go to the act, you will see it there. It has a lot of powers and functions. But some of the things I like to take while I close are the following. One, yes, there are powers to enforce. Under the law, for example, there must be annual reports. Data controllers must generate annual reports that show compliance and that shows a data protection audit. A data protection audit is one that ensures that you have all the processes in place, and that you have the capacity also. You not just say that we keep this, we keep that, we do not share this, but you have the capacity. You have security processes in place to prevent data leaks and things like that. So, but while I'm closing, let me take some nuances that are very important for us. In Nigeria, as in most parts of Africa, there are significant cultural and legal diversities with different privacy expectations. Privacy expectations. I mean, for example, nudity. Nudity in some climes has not, as far as they're concerned, it's got nothing to do with privacy. So that's one of the diversities that we have. Variations in access to technology and online services among societies. Sensitivities regarding ethnicity, religion, and profiling of citizens. Different levels of capability in areas such as technology and technology-related laws and governance. For example, someone comes across a cookie policy and quickly turns off his or her computer. You know, I've seen people do that. They associate cookie with virus. You know, there are a lot of people that actually think a cookie is a virus. Immediately they see that pop up, they just switch off from that website. So there are different levels of capacity. So this speaks to education, of course, and sensitization. There are risks, of course, depending on a high dependency of non-African manufacturers, non-Nigerian manufacturers. We rely a lot on imported technology and imported technicians. And we have a potential high risk of service being abused. For example, many organizations in Nigeria, they have cloud that are domiciled outside the country. You know, so these are some of the things that once they're outside jurisdiction, how do you reach out to them? And I think that's why the government some years back insisted that organizations like Facebook and Google and Twitter should have presence in the country. So my top points is that, well, I think we should, as the data protection authorities should intensify our guidance to vendors and service producers. Consumer protection legislation should also be engaged. I told you a little bit about that. You see what the Consumer Protection Organization, the Nigerian Competition and Consumer Protection Commission is doing in regard to online bankers, I mean online money lenders. And so you can see that in that one, even that organization is probably leading the charge, and it's not the NDPA. But I don't think that organization can do much without the NDPA, without the NDPC coming into the framework. There's a problem, well, in terms of compensation by order of court. I think this is a regulatory framework. And there's no point, I haven't talked about diversity in terms of understanding and you. There's no point still asking people to go to court, except we're talking about commercial users and also business people. I think the provisions like Section 29 that say that compensation by order of court should be ordered where there's a damage would in the long run prove to be illusory because there are serious access to justice issues, access to court issues being faced by a lot of Nigerians. And I think the NDPC should rise up to its billings as a regulatory body and undertake some of these things on behalf of consumers. I'm going to stop here. Thank you very much.
Oh, thank you so much, Daniel Silk, for that very, very educative and inspiring session. Now, I have a few questions, but because of our time, I'm so sorry I won't be able to take all the questions. I will only take 2 out of them because we have another senior advocate who is also touching on the NDPA in this session, which is next. Someone is asking if the NDPA or the NDPR and NDPA still operate side by side, or as the NDPR ceased to operate.
I can take that quickly. It was one thing on my mind. The NDPR no longer operates as of now, but I suspect that it will be resuscitated probably in a much more elaborate form. Now that there is an enabling power to make regulations and also a specialized body to enforce these regulations. So as of now, there is nothing like the NDPR, but I'm sure that very soon it's going to come up.
So somebody else is asking if where a data controller who is outside Nigeria uses or processes the data of people in Nigeria, would you still consider this an extraterritorial application of the Act?
Yeah, that's like Facebook, isn't it? So that
well,
is
Facebook has an office in Lagos.
Presence, yes,
although
Facebook has presence in Nigeria. But there are tons of persons there are tons of data controllers who are resident outside Nigeria, who operate outside Nigeria, but deal with personal data of Nigerians. Yes, they are subject to the NDPA. They are subject to the NDPA, and these are things that mutual legal cooperation can assist the NDPC bring such persons to book. But like I said, you know, the gap in cooperating with regional bodies is fatal as far as I'm concerned. You have not signed up to the Malabo Convention, and you want to now talk about mutual legal assistance. It's going to be a problem.
Right. Thank you very much, Daniel Silk. Because of our time, thank you very much for your time as well. And if anybody has any other questions, please, you can reach out to Daniel Senior Advocate after the call or anytime at all, so that you can further provide clarity to any of the questions you have. Thank you very much, sir.
Thank you, Olumide. Thank you very much.
Next senior advocate who is also touching on the Nigerian Data Protection Act. Please, Sarah, confirm that Mr. Enito SAM is on the call so that I can yield the floor to him. I can't see him in the panelist section, but please, Sarah, just confirm he's on the call.
I can't see him also. Mr. Linda, I can't see him also.
Right. Well,
let's try to.
Okay, so while we wait for him, you can just reach out to him so that he knows he needs to log in.
Yeah.
During the Daniel Silk session, there were some questions that were not answered. There were some questions that I keep getting some text messages on some of the questions and some of the issues. Number one, the first one I'd like to also quickly speak to before we have the next senior advocate is that one that relates to the NDPR and the NDPA. Actually, there's a provision in the Act that that sustains or that protects the NDPR in terms of its enforcement. That is the transition provision, I think section 64, 60, or 60, that preserves the NDPR and other regulations, other documentations made during the life of the NDPB, or even when NIDA was still the regulator. And I think the reason for that is because of the time that it takes for them to pass a new regulation. Right now, they are in the process of reviewing certain regulations that they want to pass. So they want the NDPR to still be enforced so that it can plug the gap before the new regulations come in. Also, in terms of extraterritoriality, yes, most data protection regulations or legislation in the world, they have that provision, although there's a problem with enforcement. Just a couple of days ago, a court in the United Kingdom delivered a judgment in the case of Clearview and the Information Commissioner's Office in the United Kingdom. And they had to look at the extraterritoriality of the GDPR as well as the UK GDPR. In that case, the court eventually decided that the regulator in the UK could not find a company in the US because the company did not, according to them, monitor the behavior of UK citizens. But I find that judgment a bit worrisome because some of the reasonings of the court there, even though the company has a database of Britons or UK citizens, the court still use one of the names. So, but extraterritoriality will continually give us problems in terms of enforcement and in terms of the application of either conflict of laws or whatever it is. But so that I don't waste, Sarah, please, can you, what about Mr. Uche Obi? Is he on the call as well? Okay, so I'm so sorry. So sorry, Mr. Enitor had a slight glitch and he's coming on the call now. I'm so sorry about that. I think it was a bit about the link he got. There was a mix-up about the link he got. And okay, so Mr. Obi is on the call, so we can as well just quickly proceed with Mr. Obi, then Mr. Enitor can come after Mr. Obi SAN. Mr. Obi SAN is also one of the few practitioners who have written academic articles on privacy and data protection. And he's going to be touching on the confusion that we sometimes have in identifying causes of action in privacy, apart from causes of action in data protection. Please, Mr. Obi, you have the floor, sir.
Good afternoon, everyone. Let me start by first appreciating and extending my gratitude to Mr. Tobenna Erupche and other members of the ICLA team that put this together. The same goes to the members of the stellar panel that we have today facilitating this event. It is my profound gratitude to be honored to be allowed to speak on the topical issue, the trending issue, the emerging jurisprudential issue around data privacy and protection. So I'll be running this afternoon, I'll be running a few slides on this, and it's up to the organizers to advise us when we could deal with questions or other things. My apologies for joining late. Apparently the link it didn't come through until just a few minutes ago. Apologies. I'll be sharing my screen. Please, could you confirm if you're able to see my screen?
Yes, sir, we can see your screen.
Thank you very much. So the topic that I'm supposed to deal with in these few minutes is distinguishing causes of action bordering on privacy infringements from data breaches, and to bring clarity to the bloodlines of the twin concepts to add identification of distinct causes of action. I must say that my topic is not probably the most popular one. It's a bit jurisprudential, but then it is very, very important to understand the conceptual issues and also the dividing line between privacy infringements and data breaches. At the onset, I must say, the line is very thin, but it does exist. As a prelude, I normally start this kind of paper by borrowing the famous quote of Bruce Schneider, who is a Harvard professor, a cryptographer, a computer security professional, and privacy specialist and writer. He said, data is the pollution problem of the information age, and protecting privacy is the environmental challenge. This is quite thought-provoking, and we'll be able to see how relevant this could be in the context of our paper. I will be looking at a few things which you could see in the table of content. Distinguishing causes of action bordering on privacy infringements from data breaches. We're talking about causes of action bordering on privacy infringement, data subjects' privacy rights, distinguishing privacy infringement from data breaches, privacy infringement, and data breaches. Just the point, the convergence point. Now, first, what do we mean by causes of action bordering on privacy infringements and data breaches in terms of trying to distinguish the elements? What we did was, first of all, try to define cause of action. And it's simply those set of facts sufficient to justify the enforcement of a legal right against another party. And this has received wide consideration by our courts. Just those set of facts those algorithms that will crystallize or grant a claim against a person. Those things that you can take to court and make out a good statement of claim, statement of facts. And then on the basis of that, seek relief from the courts. So, simply put, that is what we mean by a course of action. Now, it is linked to the power of the court to adjudicate. In other words, jurisdictional competence. For a court to entertain a matter, there must be a course of action made out on the face of the pleadings. If there is no course of action made out, the court would decline jurisdiction to entertain the matter and would say it does not have jurisdictional competence. We all remember the famous case of Madukola and Ikendene, which is a produced classicals. So, and that is why lawyers sometimes, when they receive, defense lawyers, when they receive a writ or statement of claim and all that, they first of all go through it. Does the court have the statutory jurisdiction? Does he have the subject matter jurisdiction? And then, is there a course of action made out on the four walls of the statement of claim? So, if you cannot see that on the face of it, the defense counsel would naturally come with a preliminary objection, asking that the suit be struck out for want of reasonable course of action. And the court is certainly likely to oblige if that seems to be the position. So the course of action would always be seen in the originating processes, be there the writ, summons, and statement of claim, petitions, the affidavit in originating application cases, originating summons, originating motions, and the likes. Now, going to privacy and infringements from data breaches. Now, what is the distinguishing factor between privacy infringements and then data breaches? First of all, let's talk about the similarities. Now, one is the parent, the other is the offspring. Privacy stirs data breaches. Privacy is larger and all-encompassing. Data breaches as a subset of it. In some cases, they use the two interchangeably. However, the difference is that the major difference there is that privacy is a larger, all-encompassing concept. Which is traceable to our Constitution. If you go to section 37, of the Constitution of the Federal Republic of Nigeria, you will see a provision on right of privacy as part of the fundamental human rights of persons. It is a law that sets out to protect individuals' right, the individual's right to freedom from intrusion into their private life, their private affairs, their family affairs, and also other kind of things. So Section 337 of the 1999 Constitution, for instance, says, the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. So it is part of fundamental human rights. The only challenge I see, and which is part of the advocacy we are doing today, is that being part of fundamental human rights will then mean that our fundamental human rights enforcement rules must be robust enough for its enforcement. Similarly, other mass redressing kind of litigation modes, like the class action, must also be robust enough to accommodate class suits that are predicated on privacy claims, which are part of the fundamental human rights. Now, we note that this provision, if you look at the terminologies used there, they are what we have in the old order. But by and large, they include all forms of electronic and digital kind of communication, messaging, and interface. And therefore, it covers everything that we need to be doing under data protection as well. And therefore, when we talk about privacy infringement today, it includes things that are personal identity, features of a human being. Your iris is part of it. Your thumbprint is part of it. Your internal dentition is part of it. So long as those are unique features through which an individual can be identified, they also fall within the law of privacy. The next thing we want to talk about is, sorry, Olumide, how many minutes do we still have so that I know how to manage the remaining time?
I think you have just about like 15 more minutes.
Okay, 15 minutes. Okay, so we'll make the slides available as usual, and then let's just fast track a bit. Now, under privacy rights of a data subject, of course, data subject is that individual whose personal data is being processed or used, being harvested, being processed, and for what looks like a commercial use. So it excludes processing of this data in the domestic setting. So we'll take a look at some data subjects' privacy rights. The right to be informed is part of them. The right to correction and rectification is part of them. The right to erasure and deletion of personal data, the right to restrict the processing of personal data, the right to easily withdraw consent, to processing of personal data, the right to object to processing of personal data, the right to be subject to a decision based solely on automated data processing, the right to data portability is one of them, as well as the right to access a copy of data subject's personal data in a commonly usable electronic format, portability. That's what it means. So these are some of the data subject's privacy rights. We've commented on some of the features. So on this slide, we try to further distinguish privacy infringement from data breaches. We know that a privacy infringement could still be occasioned by a data breach. However, aside from data breaches, there are other causes of privacy infringement, which include the ones we have on the slide there. For instance, absence of lawful basis for processing of personal data. Now, even when a data breach has not occurred, processing the personal data of data subjects without any lawful basis will trigger a cause of action for privacy infringement. Like you know, Lumide is a great activist of data protection and privacy. So I have put one of the cases he did there, and it revolves around this. Next is non-adherence to the principles of fairness and transparency. Failure of the data controller or data processor to adhere to the data protection principles of fairness and transparency could create a cause of action for privacy infringement, even when a data breach has not occurred. We have two cases we put there. One is the Google Spence case. That Google Spence case is a situation where a financial institution had alleged, correctly, yes, that somebody was indebted to them, but the gentleman has since paid his debt, and they still have that out there for the public to be seeing several years after. And the man went to court and said, look, yes, they were right in the statement they made, but I've since prepaid. So what's my name still doing out there? That he has what is called a right to be forgotten. And he sued, and then he won. And there was even damages. There were damages awarded, sorry. Now, the TikTok case is also another case in point. Here, the Information Commissioner's Office of the UK slammed a heavy fine of $15.9 million against TikTok for processing children's data without lawful consent. There's a special way of getting consent of children before you can process their data. So if you get consent from children who are underage, for instance, without affirmation of their next of kin, parents, or best friend, then that consent is invalidated, and you can still be held to have breached their privacy right, even if no data breach has occurred. But here we're talking about the process through which you are able to harvest or process the data. So contravention of purpose limitation and data minimization principles. Here we said failure of the data controller or data processor to adhere to purpose limitation and data minimization principles to create a cause of action for privacy infringements, even when a data breach has not occurred. That's also a case in point there. We will be able to release the prose version of these slides to the organizers. Contravention of the provisions of the NDPA and other principles of data protection. Now, in the absence of any data breach, violating the provisions of the NDPA and the data protection principles in circumstances where the rights of data subjects are adversely affected is more than enough to substantiate a claim against the data controller or processor. So, personal data breach, here we're talking about breach of data of organic persons, data of individuals, you and I, not data of organizations, not data of artificial persons. So, however, the law recognizes that if you breach the personal data of a human being, though late or deceased, the estate might also proceed because it's still the personal data of a human being, though deceased, but he has his legal rights continuing through his estate. So this is one feature we need to note there. Now, the NDPA defines a personal data breach as a breach of security of a data controller or data processor, leading to or likely to lead to accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. So we refer to the IBM case, IBM report that tried to attach a number to already identified certain infringements sometime this year, within this year. So data protection concerns itself with a process and issues around safeguarding important data from corruption, compromise, or loss, and providing the capability to restore the data to a functional state should something happen to render data inaccessible or unusable. So look at the applicable laws in Nigeria. We have the NDPA, and then we have the NDPR. That's a regulation that predated it, the NDPA, but allowed to function along with it. They're all instruments tackling Nigeria's data privacy and protection issues by raising the standard of data protection to meet that of EU General Data Protection Act. I must say that this is an aspirational statement, still not there, because EU is more robust. And the reason they are more robust is akin or traceable to the kind of law they operate. Civil law jurisdictions believe in codification of laws, and they, as much as possible, populate their laws with almost everything on earth. But this is not the way the common law countries approach statutes. They still believe that the statute will just provide framework, and that the operators can fill up the gaps with regulations. And in any case, there will be the court also to fill in the gaps with case law. So the EU GDPR is a product of common law codification. So we have the law requires data controllers and processors. By controllers, we're talking about the institutions, for instance, the companies that typically use this data to further their businesses. And processors could also be individuals within that company, and given the responsibility or role to process data on behalf of the controllers. Sometimes they could also use external consultants to play this role. So here we're saying that the law requires both data controllers and processors to deploy technical and organizational measures to safeguard the security and integrity of personal data. So Equifax had to agree to pay $575 million US, which potentially rose to about circa $700 million in settlement with the Fed Trade Commission, the Consumer Financial Bureau, and all the 50 United States of the US and territories over its failure to take reasonable steps to fix a vulnerability in its network that eventually led to the loss of the personal and financial information of nearly 150 million people. So the British Airways case is also a case in point. Here, the website of BA was hacked, and then the information was now fraudulently syndicated, and linked to a particular fraudulent site, which exposed passengers' personal data, and some of them were defrauded in the process, and then BA was held liable.
And let's say, thank you. We might, because we have a couple of questions also on this call, you might want to quickly draw it to an answer.
Thank you very much. So under the applicable laws, general data breaches can be categorized into confidentiality breach, integrity breach, and availability breach. And in some ways, once you commit this data breach, the law is a bit strict, tilting towards strict liability, so that the issue of intention, mens rea don't really count, because they really want to protect the data subjects. A case in point is the Marriott Hotel case, where Marriott Hotel acquired a particular company as part of its expansion drive, without knowing that they had committed some data infringement in the past, in the sense that their information were hacked, and then personal data of certain individuals have been exposed. But after the acquisition, they still did the investigation and came to Marriott, and then asked Marriott to pay substantial damages. Marriott's defense that it wasn't even the entity that caused the breach, it simply bought it over, did not avail it. So the law is tilting towards strict liability, something close to that. So we talked about personal data breach notification obligations on the data processor, data controller, and data subject. So the point of convergence, data breaches may occur in circumstances that could give rise to an infringement on the privacy and rights of data subjects. The Marriott case came to handy again. Again, technological advancements of recent years have occasioned an unprecedented increase in the amount of data processed within any given period of time. Amongst the data process is personal information of citizens that forms part of their privacy. So that's another converging point. And then we refer to some authorities, local and foreign. So in differentiating between privacy infringements and data breaches, one must consider the intent, expected outcome, and legal implications of both courses of action. I must say that mostly privacy breach, data protection, and the data breaches predominantly may ground actions in thought. But where, for instance, the data subject is alleging that there was a breach of its consent. Like, for instance, he gave consent, limited consent, and the consent, it was processed beyond the consent he has given, and or that he had withdrawn his consent or whatever. Those can also crystallize into some claims in contract. And it is very, very essential that we understand this, so that this will also impact whether you go to a particular court or the other. The same thing with negligence. Negligence can also ground an action in thought primarily. It can also be a feature that led to the breach of the contract. The concept of privacy infringement and data breach may appear similar and misconstrued simply because they all apply to privacy-related concepts and laws. However, these concepts are distinct and causes. These concepts are distinct. And the causes of action bordering on privacy infringements from data breaches are parallel sides of the bloodlines of the two concepts. One must separate them as done above to properly situate sustainable costs of action. Like we said earlier on at the beginning, the lines are thin, but they exist, and they also have some consequences. I end at this note, and I thank you once again for giving me the chance to speak. Thank you.
Thank you very much, Alessio. So we'll quickly move to the questions. Again, because of our time, so sorry, because of the transition and the time we wasted during transition, I will restrict this to just about 2 of the questions. Someone is asking if our information in the bank constitutes personal data vis-a-vis the account balance.
Oh, yes. They are personal data and they are protected. So if a bank goes ahead to divulge the customer's balance or details of the account, the transactions and all that, or even information made available by the customer at the point of opening the account, like the mandates, like date of birth and all that kind of stuff, they constitute significant data breach. In fact, there's even a case that affects one of the banks in Nigeria who used the information given by one customer to open another account for that customer without the customer's consent and authorization. The court held that it amounts to data breach.
Thank you, sir. So I'm sorry, I see so many questions flying in, but because of our time, I'm so sorry, some of the questions we can't take. Someone is asking if data breaches can be situated or litigated under fundamental rights procedures or fundamental right matters.
Oh, yes. Where the data breach also amounts to infringement of privacy. In most cases, they should. Then you can initiate action under fundamental human rights because they are part and parcel of the individual's fundamental human rights that the law has set out to protect, that the Constitution has said that you do not violate. And therefore, if there is violation and it is brought very, very well, and the ingredients are very clear, that it tantamounts to the breach of that individual's fundamental human right to privacy. Yes, it can be brought under a fundamental human rights enforcement action.
Okay, so before I ask the last question, I see so many people asking how they can contact or whether we can share the details of the facilitators. This is a data protection training, so we won't be doing that, but you can reach out to them on social media or you reach out to the NBA. The NBA can seek their permission and then they can share their, I see a whole lot of emails flying in from the chat room or from the question and answer section where I see people putting their email addresses and their telephone numbers. Maybe we don't take these things as seriously as we should take them, but ordinarily, if we begin to have serious data protection consciousness, even though this is a professional platform, yet emails should not just be flying around indiscriminately, especially with phone numbers and some other personal data like that, because we now have systems where such emails can lead to some other intimate information about the holder. Anyways, now the last question here says, can data privacy or data breaches or data infringement be filed in any court, including a magistrate court? I know that question is coming from the Nigerian Data Protection Act.
Well, the Act anticipates High Court. And the High Court, we should know, will be, the question should rather be, will it be the Federal High Court or will it be the State High Court? So those are the issues. So it depends, again, where you take the matter to. If you approach it as a fundamental human rights action, then both courts have jurisdiction. if you approach it as an action grounded on thought, a tortious action, then of course it moves closer to the state high court. But so it depends. It just all depends what the ingredients are, but there are a lot of nuances. Actually, this can't be done under 30 minutes. There are a lot of nuances involved in all these things to check and double check again, and then before you know how to do it. Because, for instance, one interesting thing about, one interesting thing about data protection is it's a new jurisprudence. It's different from what we had before. And I give you an instance. Under the law of tort, defamation, for instance, if you defame somebody or there is an action grounded in defamation, libel, slander, or whatever. Now, once the defendant is able to show justification, in other words, what there was truth in what he published against the plaintiff, the action fails. You can't succeed. But in data protection, even if what has been said about that individual, the data subject, is correct, the law is interested, whether it is correct or not. Do you have the right to divulge it to other people? Do you have the right to violate his data rights? Do you have the right to infringe on his privacy? So the point that it is correct or is true is no more a defense. The law is, yes, it may be right, but what right do you have to disseminate? What right do you still have to keep it? What right do you still have to do it? So those are some of the things that we need to point out to our colleagues, that look, there are slight differences in this new emerging jurisprudence.
Thank you very much, Learned Silk, for your time, and thank you. I'm so sorry to everybody who has one question or the other that we cannot touch. The time cannot really permit. Just like the Learned Silk said, data protection is an emerging jurisprudence. Some questions don't have clear answers yet. Maybe when we go to court, or maybe when the academics really dissect some of these issues, we can begin to have answers to them. For example, the question of the magistrate court, the Nigeria Data Protection Act is so uncertain with respect to the applicable court, because it simply states court of competent jurisdiction. It could be any court, but I understand Solomon Okedara has approached the Federal High Court for an interpretation of that provision. Also, from our own end, we have even filed some cases at the magistrate court to test the law on some of these things. So it behoves on all of us to continue to develop this area of our laws. And you mentioned the difference between defamation and privacy. That's one of the things we'll be touching on in the last training, because in that session we'll be looking at the cases. We'll be reviewing some of the cases that have been litigated around privacy and data protection, and especially the ones that could have properly been litigated under privacy, especially when you are looking at the privacy interest. But that would be on Thursday, I suppose. So thank you very much once again, Learned Silk, for your time. I'll move quickly to the last but not the least of the facilitators for today, who would also be looking at the Nigeria Data Protection Act and some of its provisions and the nuances. Please, Mr. Kayode Enitan, SAN, you have the floor, sir.
Good evening, everyone. And let me take off by appreciating the NBA ICLE for the training and the opportunity to present. I hope I will not bore anyone, and at the end of it, we would all have been mutually enriched. I've been given a topic, overview of the Nigerian Data Protection Act 20, exploring the regular, peculiar, controversial, and remarkable provisions. Now, the topic itself already suggests to us that there are things that we need to fish out. Now, by way of an introduction, it's obvious from all that we've listened to so far that we are in an age where data is constantly moving from one point to the other. I would try as much as possible not to go over what has been said since I've been in the training from commencement. So we may see some things on my slides that I will just jump. That will be because it's been touched upon by those who came before me. But it suffices that we appreciate that right now, in this time and age that we are, data is constantly moving from one point to the other. It is being stored on a per second basis, and technology that is deployed in doing this is so wide and vast. And through all of this, we are all online, we are doing stuff, we are sending information. This wealth of data contains are very, very personal to us. Mr. Babalola, a couple of minutes ago, mentioned how emails are flying around. Now, each of these things that we are constantly pushing out has they've necessitated or they've brought about breaches, and in recent times there have been breaches, WhatsApp, so-called lending, LinkedIn, Sina, Weibo, MyFitnessPal, Alibaba, Marriott Intercontinental, Starwood, LIRS, and several other. Most recently, Sony notified 6,791 current and past employees that their data were, there have been data breaches on MoveIt software platform. This year, just a couple of weeks, on September 27th specifically, a staffer of the Senate informed Reuters of that US Senate that Chinese hackers stole over 60,000 emails from State Department officials. Every one of these things shows our exposure and the concern that the Nigerian government has towards its date of 2001, when the National Information Technology Development Agency was created, and that moved in 2007 to the NTDA Act itself, which progressed to the NDPR in 2019. The first response of the Nigerian government was the enactment of the NDPR implementation framework. From that one, they moved to bringing up guidelines for management of personal data by public institution, which is to separate, okay, government agencies and all public institutions. This is how they should manage data. And of course, progressively, we moved up to the NDPB in 2022, and which has now metamorphosed into the NDPA 2023. And of course, right now, we now have the Nigerian Data Protection Commission, which has taken over from the NDPB. Now, the Act up to date has come off after 23 years of advocacy, of demand, appeals, and along that path. Now, stated in the explanatory memorandum of the current Act is a not as a regulatory body governing the processing of personal information. It is worth noting that this came in the wake of the NDPB, which was brought up last year, 2022, and which was overseeing all of the aspects of the law. However, by Section 64 of the Act, we have a transformative shift in the landscape. This section moved every one of the responsibility and authority of the Bureau to the Commission, and giving it new life and power to do the things that it needs to be done. As a result of the transition, the Commission handles all the core functions, associated rights, powers, remedies, documentation. Everything that the Bureau was doing is now fully domiciled in the Commission. Now, let's go to our keywords. We are to look at what are the regular provisions, what are the peculiar ones, what are those that are seemingly controversial, and what are the ones that are remarkable. Regular provisions. By this, we are looking at those that majorly just more or less mirror what has been contained in the NDPR 2019, as well as those that were inspired by the UK GDPR, hence the use of the term regular, that is those that have been around and before. The principles are contained in Section 24, and these are the things that were also in Article 2.1 of the NDPR, which is the precursor. Now, we've heard how data is meant to be processed. Professor took us through all of that. Professor took us through issue of security of personal data, how it's to be processed, and all of that. So I would not want to spend too much time on all of this. Now, the point that I would want to look at is the issue of consent. Section 26 of the Act incorporates provisions that emphasizes the importance of obtaining explicit consent from data subjects before processing the data. It clarifies that silence or inactivity those areas where it is clearly stated, regular legal maxim is that silence would mean consent if it is in respect of an official communication. But when it comes to issue of data data privacy, silence is not consent. This is an improvement on Article 2.3 of the NDPR. Privacy policy, there is not much difference in the content of the act as well as the NDPR Article 2.5, other than minor difference in phrasing. Now, this is with regards to obligation of data controller to publish its privacy policy in a clear, concise, transparent, understandable, and easily accessible format. I would also not want to stay too long on this. Now, designation of a data protection officer. This is was contained or still contained in Article 4.12 of NDPR and is replicated in Section 32 of the Act. The rights of data subjects is contained in Sections 34 to 38 of the Act and basically enhances Part 3 of the NDPR. So there is not much to belabor ourselves with in respect of that. Now, Section 40 of the Act, which is similar to Article 12 of the NDPR, relates to notification of data breach. Where you have a data breach, what is the controller expected to do? He has 72 hours of becoming aware to notify the commission of the breach, describing the nature of the breach, categories, approximate number of subjects that have had their data exposed, and what kind of personal records are affected. Transfer of personal data. Now, this is contained in Sections 41, 42, and 43 of the Act, and serves basically as an augmentation of Article 2.1 of the NDPR. It states how data is to be transferred from one location to the other, particularly with regards to extraterritorial transfer. You're moving data to another jurisdiction. Noteworthy here is Section 41(1) and 4, which states the fundamental basis of transfer to another jurisdiction. And that is basically to say the controller must ensure compliance with at least one of the bases enumerated in Section 43. It's essential, however, to emphasize one of Section 42 of the Act, which contains conditions for accessing the adequacy of protection should not be disregarded. Now, let's move to the that because the NDPR implementation framework or the guidelines for public institutions, they stand out. These provisions stand out because they bring in new elements and those of proof for establishing data subject consent placed on the data controller the burden to prove the data subjects have indeed given their consent to the processing of their personal data. In this regards, when a data controller is saying processing is consented to or not, of showing that, oh, the subject actually consented. So he must show and that it was obtained in a legitimate and verifiable manner. The data subject does not need to prove anything. It doesn't need to say anything. Now we ask the, let's ponder on that. We will come back to it. Section 28 of the Act brings this out. It's a structured evaluation conducted by a data controller. This is placed on the controller itself to, on its own, do an assessment where he knows that, oh, there are risks. What are those risks? What kind of data would likely be collected and may be affected? For instance, the mandatory NIN registration that we've all had to do, the BVN that we've all had to do, the impact assessment is meant to have been done under this provision of the Act. Then the next one is the obligations of the data controller stroke data processor. This has also been enhanced. Under the NDPR, these roles were used casually and in a somewhat conflictual manner. They were called data administrator under NDPR. The Act, however, has used the term data processor, which is more comprehensive and more relatable compared to data administrator. So Section 29 contains the obligations of the data controller or a data processor engaged by a data controller or a data processor engaged by another data processor in the processing of personal data. This provision is totally absent. And you can see how this have been used. Under the Act, it's clearly and explicitly delineated. Data processor is used under the Act instead of data administrator. Roles and obligations are not clearly defined under NDPR. Section 29 clearly defines this under the Act. And of course, under the Act, it's a more enhanced provision. Then we move to processing of children's personal data. No, sorry, processing of sensitive personal. This is defined in Section 65. And because of risk associated with them, establish the legal basis and conditions for processing personal data. So this, when you look at Section 31, 30 subsection 1A to I of the Act, you will see the specific provisions. Now let's speak processing of children's personal data. Section 31 makes provision for how data pertaining to children or persons lacking legal capacity to give consent are to be processed. 31.1 says to rely on consent as basis of processing the personal data of a child or person lacking legal capacity to give consent. A data controller must obtain the consent of the child's or person's parent or their legal guardian. The data controller shall further apply appropriate mechanism to verify the age and consent, taking into consideration available technology. This you see in section 31, sub 2 of the Act. Thus, of particular importance under the provisions of section 4 is the necessity to protect the vital interests of the child or person lacking legal capacity to give consent, that the processing is carried out for the purposes of education, medical or social care, and undertaken by or under the responsibility of a professional or similar service provider owing a duty of confidentiality, and also that the processing of the child or person lacking legal capacity to consent data is necessary for proceedings before a court relating to that specific individual. It's implicit to say, with the exceptions outlined in section 31.4 of the Act put aside, the processing of a child's personal data requires explicit consent of a parent or a legal guardian. And the definition of a child is as stated in the Child Rights Act of 2003. Data Protection Compliance Service is also one of the peculiar provisions, which is stated under section 33. It vests on the NDPC the power to grant license to individuals with necessary expertise in the field of data protection. These licenses are issued for specific purpose of monitoring, auditing, and reporting on the compliance of data controllers and data processors. However, section 31 of the Act inquires as to whether it signifies a modification, deviation, or augmentation of the NDPR. So let's move to the remarkable provisions. These are those provisions in the Act that are notable because they introduce unique measures designed to enhance the protection of personal data. These provisions stand out for their potential to address emerging challenges in the field of data protection and to better safeguard individuals' privacy rights. And they are as follows. Section 2, subsection 2. First, section 2.1, which states the application of the Act. It goes to town stating specifically what it's meant to achieve, and this is a significant enhancement of the NDPR, which was just regulated. It's that in the section 2, I'm sure we all remember what those things we used to experience, where you see somebody's TV at the groundnut seller. If such a thing were to happen today, there will be someone to, at least once the subject knows exactly who that particular document was delivered to, then he knows who to hold. So in the application of the Act, there is remarkable provision. Subsection 2 of Section 3 also contains exceptions to the application of the Act. So it's important to state that the Act does not apply to every data processing activity conducted by a data controller or data processor. Now, another of the remarkable provisions is the registration of data controller. And this you see in Section 44. It says major data controllers and processors must register with the Commission within 6 months of the Act's commencement or of their becoming a significant data controller or processor. This section aims to regulate data controllers and processors, substantial data holdings, and the potential consequences of unauthorized disclosure and breaches which cannot and definitely will not be ignored by the Commission. Another significant provision is transferring data from Nigeria to other jurisdictions. Under the NDPR, there is specific rule under Article 2.11 for the consent of the Attorney General of the Federation. The Act is totally silent on whether that consent is still required. And of course, where the Act is silent, based on the fact that they are both still running pari passu, my opinion would be that rather than seeking the consent, the data controller should just ensure that it complies with the provisions of the Act in moving the data outside the Nigerian jurisdiction. Enforcement. This is in Part 10, Section 64. Section 64 clearly stated. However, if you stroll back to Section 46(1), which empowers data subjects who have grievances concerning actions or inaction of data controller or processor in violation of the Act or subsidiary legislation to file their complaints with the Commission. Upon receiving such complaints, the Commission is obligated to conduct investigation, provided that the complaints are not frivolous or vexatious. That's in Section 46(2). Consequently, unlike the NDPR, which solely addresses the establishment of the Administrative Redress Panel in Article 4.2 and cost of penalties in event of default in Article 2.10, Part 10 of the Act comprises comprehensive provisions. It not only encourages data subjects to file complaints if they are dissatisfied with the decisions, actions, or inactions of data controllers and processors in handling their personal data, but it outlines the Commission's responsibilities in addressing these complaints effectively. Part 10 also delineates potential compliance orders and sanctions, including criminal liabilities that the Commission can impose. As it also, there is also provision for judicial review under Section 50. That is, if Commission takes a position and you are not happy with it, you can go ahead and seek judicial review within 30 days. Another enhancement or removable provision is the Commission's power of arrest, search, and seizure, which is contained in Section 58(1) of the Act. By that, the Commission is vested with the authority to make ex parte application to a judge in chambers for issuance of a warrant of connection with an investigation. Subsection 2 delineates the specific circumstances that will justify the issuance of such a warrant by the judge. Additionally, subsection 3 delineates the powers vested in the Commission following the issuance of the warrant by the judge. Now, on this, I will quickly want to dovetail back to something that was mentioned by Mr. Babalola earlier at the conclusion of the earlier paper about testing of the provisions. Since the Act didn't state specifically which court has jurisdiction, I think if we are to look at the Act as a whole, particularly looking at Section 58, which states exactly where the Commission should go and says should go before a judge in chambers, I'm of the view that that would automatically suggest that a magistrate court should not have competence to deal with the issue of either data breach or an improper dissemination or processing of a data subject's information. Now, also on the issue of the, okay, I would get to that towards the end of the paper. Let's go to controversial provisions, at least from our peculiar prism. I'm sure others may be able to find additional. First is the Administrative Redress Panel. What has happened to it? Section 64(f) of the Act provides for rules, regulations, decisions, directions, licenses, authorizations. That is the transition provision. Everything that NITDA, NIDP, that were being done under the previous Act, everything that they had done, whatever it is they were doing, what documents, whatever issues they had given, everything they had done should automatically transit to the Commission until expiration or repeal, replacement, reassembly, or alteration. Implicit here is that the NDPR is still existing and in effect. Since it didn't have an expiration date and it has not been expressly repealed, replaced, reassembled, or altered. So one can say that the NDPR is still alive. However, its existence is to the extent that it does not contravene or contradict the provisions of the Act. So, we ask the question, we record, then we come again to the Administrative Redress Panel, which was created under Article 3.2.1 of the NDPR. And under that particular article, the data subject has a power of election to either go straight to court or to seek the recourse through the administrative panel of the under the NDPR. The Administrative Redress Panel undertook investigations of allegations of any breach, invitation to parties to respond to allegations of breaches. They issued administrative order and informed and had a timeline, 28 days, to complete whatever it was doing.
And then, please, we'll have just about less than 10 minutes to
yes,
end.
we will wrap up. So this is no longer Section 46 of the Act just bestows authority and jurisdiction to receive complaints on the commission. So is the panel still existing? That is a question that we will answer in the further development of the law. Now, issue of penalties for breach. Article 210 of the NDPR states clearly a mandatory liability of 10, if it's a 10,000 data subject controller, 2% of annual gross revenue or 10 million naira. If it's data controller dealing with less than 10,000 subjects, 1% of annual gross revenue of preceding year or 2 million naira, whichever is greater. Section 48 of the Act, on the other hand, states sanctions and orders the Commission may impose. And of course, it says NDPR and the Act plays mutual role somewhat. Question that arises is, in case of a breach, does the Commission have a discretion to apply sanctions under NDPR or the Act or both? I'm of the view that whilst under the NDPR, there is no discretion on the part of NITDA, then with regards to payment of penalty, such a discretion, though the NITDA used to exercise that discretion, though there is no provision under the regulation, the Commission has a discretion, and my authority for this is Section 48, subsection 3 and 6 of the Act, which used the word may. And in stating what the Commission can do, it gave several this or this or this or that or that or that. Then border transfer of personal data. We've said, I've mentioned the issue of consent of the Attorney General earlier. So that is totally not mentioned in the Act, and it will be assumed that it is not necessary. DPCOs and DPCOs, Data Protection Compliance Organization and Data Protection Compliance Officer, Section 33 of the Act grants the Commission the authority to issue licenses to the DPCOs. The pressing question that arises here pertains to the potential coexistence of both a data protection compliance organization licensed by the Commission and an individual with data protection expertise also licensed by the Commission. These entities may appear to have overlapping functions, and this will require a closer examination of their roles and responsibilities to determine whether duplicative efforts may emerge. The scope, our scope today and time will not permit us to go into all of that. Now, can the violation of the Act be considered an infringement of the right to privacy? We have 3 cases that we've cited as to the position of our courts in respect of them. In the fuller paper, which would also be circulated, several jurisdiction provisions in several jurisdictions were referred to, and you would be encouraged to read all of that. Now, which court has jurisdiction? There is absolutely nothing stated in the Act as to whether it is Federal High Court or the State High Court. As we heard earlier, all it says is that a court of competent jurisdiction. My personal view, where the action is against the Commission, I think the provision of the Section 251 of the Constitution should kick in as to going against a federal government agency or seeking an injunction against its administrative or statutory acts, the things that it had done that you want to have reviewed, or you want to have declared to have been either unconstitutional or ultra-vires the act itself. I'm of the view that the Federal High Court will have jurisdiction in respect of that. But where it relates to an improper processing of a subject's personal details, or a breach or a claim for damages against a data controller in respect of a breach, I'm of the view that the State High Court should ordinarily have jurisdiction, since, or except to the extent limited by acts of Parliament, the State High Court and FCT have somewhat unlimited jurisdiction. So while the Act has not made specific provision, I'm of the view that when it relates to the administrative actions, or to hold the Commission to order or to compel the Commission to take steps, the Federal High Court should have jurisdiction. Where it is in relation to data subjects as vis-a-vis data controllers, it should be either Federal High Court or State High Court. In conclusion, the enactment of the Act underscores the Nigerian government's commitment in the privacy of individuals and their personal data. And this has been ongoing for 23 years. And I think, seriously, this area of our law is the one that we can actually see traction on an incremental basis. Since 2001, almost within every decade, there has been a move forward. And there has been tremendous traction in this third decade of the existence of data protection, at least conscious data protection in Nigeria. So it's a commendable stride that has gone on so far. Nonetheless, it is worth noting that the Act has also faced criticism due to certain conflicts with the provision of the NDPR. However, like I've opined, where there is conflict between the NDPR and the Act, it's clearly stated in the Act that the Act should take preeminence. There is need for clarification in our data protection laws and regulations. And as we also learned, the regulations are also being revised, at least in the very near future. I'm sure we will see subsidiary legislation by way of regulations made pursuant to the Act itself, and not anymore under the NITDA Act. Thank you all very much for listening, and I hope I have not bored us too much. And
thank you very much.
you, ICME and Mr. Babalola, for
Thank you very much, NSC.
staying on my feet till this day has happened.
Thank you very much for your time, sir. Now, very quickly, just one question, because we know our time is fast spent. We're supposed to only spend 2 hours on the call. Now, someone is asking if Section 64 of the Act is a condition precedent to bring in a matter before the court. That section that refers to reaching out to the regulators and like internal remedies.
Well, hold on, I'm trying to get the Act so that we are not.
Yes, the section.
Okay, a reference. No, that's
Section 64.
Transitional. Section 64 talks about transitional provisions.
I think it was a wrong section the person referred to. It won't be Section 64. It will most likely be
the one speaking to the notification.
Complaint and investigation. Complaints. That should be Section 46 actually.
Section 46.
That is the rights or the options.
Okay. Complaint and a data subject is agreed by decision, action, or inaction of data controller.
Yes.
Violation of acts may lodge a complaint with the commission.
Yes.
Now, the question is what again?
Whether it constitutes a condition precedent.
To go into court.
Yes. Actually,
no, there is no such provision that mandates a data subject to seek first this recourse. And there's also nothing that specifically says you cannot proceed. Now, of course, if it's always advisable to go to the commission, because the commission has a faster mechanism for dealing with your complaints. The commission has the power to force the controller to respond immediately within specific timelines to other. But if you go to court, we all know that your first 30 days, you're still trying to serve and all of that. If you go to the state high court, if it is Lagos, your first thing for suit number, then after you have found it and you have served, the defendant has 42 days to respond. Within which time, if you had gone to the commission only needs to send a mail to the data controller. There is this allegation, respond. everything you want to get in court, the commission can actually give you by way of
Thank you very much.
remedies. All kinds of remedies is contained. And if it is found to have been a criminal, the commission has its own right to then lay a criminal complaint. They
Thank
can
you
even
very
go
much.
in and seize documents. So you are encouraged to go to the commission first.
Thank you very much, Leonard
Thank you.
Silk. I'm sorry, as much as I would like to read some of the questions, our time again would not permit. We have taken so much of your time today. We've spent like 2.5 hours on the call. Tomorrow is another day where tomorrow we have Honorable Justice Ibirunke Harrison and Mr. Bangboye from the commission, who would be speaking to data protection compliance and litigating privacy and data protection in the courts. Thank you very much for your time, for all of you that joined the call, and for all the facilitators that gave up their time and their resources for this. Thank you. We'll see you tomorrow. Bye.